The Legal Aid Foundation of Los Angeles, or LAFLA, is a nonprofit law firm that protects and advances the rights of low-income and underserved communities. Our mission is to ensure that everyone can have access to the justice system. Additional services that LAFLA provides include domestic violence clinics, criminal conviction expungement clinics, family law assistance, Asian Pacific Islander community outreach, housing and eviction defense assistance, and many others. For a full list of services, self-help centers, and available clinics, please visit www.lafla.org or call 1-800-399-4529 for more information or to apply for legal services. Since 1929, LAFLA has fought to achieve equal justice for people living in poverty across Greater Los Angeles. We do that by providing free civil legal aid to low-income people in Los Angeles County. LAFLA has 5 neighborhood offices: Westlake MacArthur Park, East Los Angeles, South Los Angeles, Santa Monica, and Long Beach. We run 3 domestic violence clinics, one at the downtown courthouse Stanley Mosque, one in Santa Monica, and one in Long Beach. And LAFLA helps staff 4 self-help legal access centers at courthouses in Inglewood, Santa Monica, Long Beach, and Torrance. On this slide, you can see a list of the services that we provide. For more information, please visit www.lafla.org or dial 1-800-399-4529 for more information or to apply for legal services. Please note, this presentation is designed to explain the current law as of the date of this presentation. This presentation is not intended to provide legal advice or strategy on how to start or complete a legal case. This presentation only provides general information and procedures. This information is not a substitute for professional legal advice from an attorney. Please consider consulting an attorney about the specific facts of your case. In order to apply for legal services from the Legal Aid Foundation of Los Angeles, please visit www.lafla.org or dial 1-800-399-4529. In this presentation, we will be discussing the eviction trial process. Evictions are also known as unlawful detainers. We will cover how to prepare for court and what happens during trial. We will also discuss the court's decision, and what happens if you win, and what happens if you lose, including the final notice to vacate. The trials in unlawful detainers may appear less formal than other superior court trials, but the exact same rules and procedures apply. Therefore, you should listen carefully to this information. An unlawful detainer begins with some type of notice. The most common is a 3-day notice to pay or quit. That means you have 3 days, not including weekends and holidays, to pay the amount of money stated in the notice or leave the apartment. However, there are many different kinds of notices, including notices to cure quit, to perform covenants, and no-fault notices, so you will want to consult with an attorney if you receive a notice. If you do not comply with the terms of the notice in the time period stated, you will receive a summons and complaint. A summons is a document ordering you to appear in court. A complaint is a document containing all of the allegations by the landlord against you. Once you receive a summons, you have 5 days, not including weekends and holidays, in which to file your response, which is called an answer. The answer will contain all of your responses to the landlord's allegations against you, and will assert any legal defenses that you may have. If you do not file an answer within the required time period, you may face what's called a default judgment. A default judgment means that you have lost your case automatically and will be required to leave the apartment. You may also owe money and have an eviction on your credit, so you will want to avoid a default judgment by filing an answer. Once you've filed an answer, there are 3 ways in which an unlawful detainer case can be resolved. One is called a stipulation. A stipulation is an agreement between you and the landlord to either pay the amount of money they claim you owe and stay, or to move out. Stipulations contain very important terms, such as whether or not the record will be sealed and whether or not you will owe any money. We'll discuss stipulations in more detail later in this presentation. The other possibility is that you could win your trial based on a legal defense. If that happens, the eviction stops and your tenancy resumes. You will still have to pay rent and abide by all of the promises you made in the lease. Sometimes tenants can win something called a conditional habitability verdict. That means that the conditions in your apartment were so bad that you didn't owe the amount of money that the landlord claimed you did. However, if you win a habitability case, you will have a few days, generally 5, in which you must pay all of the back rent at a rate reduced by the court in order to stay. If not, the landlord will get possession of the apartment and you will have an eviction on your record. The other possibility is that you will lose your case. If you lose your case, you will likely owe money and have an eviction on your record. After you lose, the landlord will get something called a writ of possession. A writ of possession is a document ordering the sheriff to lock you out of your apartment. Once the sheriff receives the writ of possession from the landlord, they will post a 5-day notice to vacate on your door. And after the 5 days in that notice are up, the sheriff will come to lock you out of the apartment. Next, we will discuss the unlawful detainer trial in more detail. Once you have filed your answer, the landlord can submit a document called a request to set case for trial. And by law, the court must set the case for trial within 20 days after that request has been made. Once that has happened, the court clerk will mail you and the landlord a trial notice with the information about the trial, including the exact date, time, and location of the trial. You must appear at trial or you will lose your case. There are 2 different types of trials: bench trials, which are decided only by the judge, and jury trials, which are decided by a jury. Very often, it is in people's interest to request a jury trial, because that gives you leverage in negotiating with the landlord, as jury trials are quite expensive. In order to request a jury trial, you must file a jury demand no later than 5 calendar days after the clerk's mailing of the trial date, and you must post jury fees, $150, if you do not have a fee waiver request, particularly an additional fee waiver request known as FW002, granted before your trial date. Remember, you must complete all the extra documents required to have a jury trial. That includes general and special jury instructions, witness and exhibit lists, and a statement of the case. These documents are required, and the court will not feel sorry for you just because you are not a lawyer. If you lose at trial and want to appeal or cancel the judge's order, the eviction is not stopped. The only way for you to stop or delay an eviction is to ask for a stay of execution. Stays of execution are very difficult to obtain and are quite complicated unless you have an extreme hardship, which will prevent you from finding or moving to a new apartment. To prepare for trial, you are going to want to gather and organize all of the evidence that you will be using. You will need to bring 3 copies total, the original and 2 other copies. That's because you must provide a copy to the landlord and a copy to the judge. The types of things you will want to consider bringing are things like certified reports. Please note that you often have to get a report certified in advance of the trial. So if you're going to use a certified document, you'll need to start that process right away. You may want to bring photographs of the conditions, letters, notices, text messages, emails, or voicemails that the landlord has left you or you've left to the landlord. You're going to want to bring proof of rent payments, including rent receipts, copies of checks, and money orders. If you plan on having another person testify, called a witness, the witness must testify in person. A signed letter or notarized statement from the witness will not be allowed. If you want to make sure a witness appears, you are going to want to subpoena the witness. If your subpoenaed witness asks, you must pay their mileage and witness fees. The court will not give you more time to collect evidence or prepare for trial if you are not prepared and ready to go on your trial day. So it is very important that you gather all of your evidence and have it ready in advance of trial. On the day of trial, you're going to want to arrive early. If you miss your trial, you will lose. Also, courts can be confusing and crowded places, so you want to arrive early enough to make sure that you get to your trial room at the right time. You're going to want to dress conservatively and neatly, because you want to impress the judge and the jury with the seriousness of your case. We do not recommend bringing children into the courtroom unless they are going to serve as witnesses, as they may distract you, the jurors, or the judge. Additionally, you may not want your children to hear some of the things that are going to be said in court. Please note that some courthouses have free child daycare for persons who have business at the courthouse. The court is required to provide you an interpreter, but if you speak a rarely used dialect, you may want to bring your own interpreter and see if the court will allow them to interpret for you. You must bring your witnesses with you, and you must bring all of the evidence that you're going to use, because the court will not give you an opportunity to go get more. Remember, you must bring the original and 2 copies, one for the landlord and one for the judge, of all the documents you're going to use. It's also a good idea to bring pen and paper so that you can take notes during the trial. When you arrive to court on the day of trial, you're going to want to look for the docket list outside of the courtroom. This can either be a piece of paper or it can be on a TV screen. You're going to want to find your case and write down the number to the left of it. That's your docket number for the day and the number the court may use to call your case. At some point in the beginning of the proceedings, the clerk will call roll. They will call out everyone's name to see if they're there. When you hear your name, you're going to want to let the clerk know that you are indeed there. If you want to settle your case, you're going to want to find the landlord's attorney and ask to speak with them in the hall. That's where you will negotiate the terms of any agreement that you may come to. Please remember to turn off your phone when you're in the courtroom. Judges do not like to be interrupted by ringers going off or text messages dinging on your phone. The judge may begin the proceedings with a speech about the unlawful detainer process that the judge uses in that courtroom. You will want to pay attention carefully to everything the judge says. After that, the judge will begin calling cases. When the judge calls your case, you will want to stand up, say your full name, and indicate that you are the tenant or defendant in that case. If you are using evidence or calling witnesses during your case, you will need to prepare an exhibit and witness list. Exhibits are what we call documents that you intend to use during your case. On the exhibit and witness list, you will list all the documents that you intend to use, and you will give them a number starting at 101 and going up. You will also list all the witnesses you intend to call and include a brief description of what they are going to testify about. You will need to print out these exhibit and witness lists, 3 copies, one for you, one for the landlord's attorney, and one for the judge. When the trial begins, the landlord will go first. That's because it's the landlord who must prove their case in order to have you evicted. The landlord, called the plaintiff in court, will present evidence as exhibits and call witnesses to reveal why you should be evicted. Take notes of what these witnesses say and what the landlord says, but do not react to their statements, even if their statements are untrue. You will have an opportunity to present your case once the landlord is done. After the plaintiff questions their witnesses, you can cross-examine them. The purpose of cross-examination is to challenge the witness's testimony. It's not the time to tell your side of the story, and it's not the time to tell the judge that the landlord is lying. You must wait your turn to tell your side. If the landlord is using documents or photos as evidence, the landlord must first give you copies before giving them to the court. You have the right to see the original document that the landlord intends to use. After the landlord has finished presenting their case, it's your turn to present your case. You're going to want to talk to the judge like you are telling a story. You want to be concise and state the facts. You may want to make an outline or chronology so you don't forget anything important. The judge may interrupt you to ask questions. When the judge or anyone else asks you a question, you want to pause before you respond and answer only the question that they asked. Don't offer more information than was asked. After you finish testifying, or your witnesses finish testifying, the landlord can now ask you questions during their cross-examination. When they ask you questions, again, pause, take a breath, and then answer the question that they asked, and nothing more. At the end of the case, the judge may let you make a final statement. In your statement, you should tell the judge why you think you should win, and you should specify what facts support your legal defenses, and why the landlord's facts don't support the landlord's claim. The judge cannot make a decision based on the fact that you have a family or that you have no place to go. A judge can only make a decision based on facts related to legal claims in this case. Next, we are going to discuss the court's decision, which is also called a judgment. You may want to ask the judge to give you what's called a statement of decision before the judge rules. A statement of decision explains the reasons why you won or the reasons why you lost, and usually they are written for your records or for the unlikely event of an appeal. However, in an unlawful detainer, you should expect an oral statement of decision, because a judge is not required to give a written decision in an unlawful detainer trial if the trial lasted less than 1 day or less than 8 hours. The judge will usually give you a decision in your case while you are still in court. Most often, they give it to you right at the end of trial. However, if they don't, you will be notified by mail of the court's decision, usually within a few days after the trial. The court's decision in a case is called a judgment. You will receive a copy of the judgment in the mail after your trial. The court's written decision should contain the following: if you are allowed to stay because you won, or if you have to move because you lose. The decision will also state whether or not you have to pay back rent. And it will also include information as to whether or not the other side gets attorney's fees or costs awarded to them. If you win and want the other side to pay your costs, you must file a memorandum of costs with the court within 10 days after trial. Whether the losing side may have to pay the winning side's attorney's fees is dependent on the rental agreement. If the rental agreement says the prevailing party gets fees, then whoever wins gets attorney's fees, though these may be capped, sometimes at $500. You do not get attorney's fees if you represent yourself. And if a lease does not contain any information about attorney's fees, then no one gets them. If you win your case based on a habitability defense, that is, a claim that the conditions in the apartment are so bad that you should not have to pay the amount of money the landlord claims you owe, the judge will order you to pay at least a portion, but very often all, of the back rent that you owe at a reduced amount within 5 days. If you pay this amount on time, you do not have to move out. If you do not pay on time, your landlord can file for a writ of possession to have the sheriff lock you out. If that happens, there will be a judgment for the plaintiff, you will have lost your case, and will have an eviction on your record and may owe the landlord money. If you win and the judge does not make you pay any back rent, the landlord will probably serve you with a new notice to pay rent or quit. If you do not pay the rent and do not move out, based upon that notice, your landlord may start the eviction process all over again. If you lose your unlawful detainer case, you will be evicted. You will want to ask the judge for more time to move if you need more than the 7 to 10 days the judge will give you, though you may not get any more time than that. You would want to say something like, "Your Honor, I request 30 days to move," but make sure you can explain why you need more time. And keep in mind, you might have to pay rent for that extra time. You can also ask for relief from forfeiture, which is an extreme hardship motion, if it's appropriate. If you're granted relief from forfeiture based on hardship, you will have to pay all the money that you owe, including back rent, costs, and attorney's fees, within a relatively short period of time. However, if you pay that money, then you will get to stay as a tenant, and you will owe rent going forward and will have to abide by the lease. However, the landlord will still have a judgment against you, and you will have an eviction on your credit. If the judge does not give you more time, you do not have to move out the same day as your trial. The landlord still needs to get a writ of possession and take it to the sheriff. The sheriff must process that writ and serve a 5-day notice to vacate. The sheriff will post this lockout notice, which will tell you when you need to leave. You get all 5 of those days. We start counting the day after the notice is served, and you get all the 5 days after that. So if it's served on a Monday, we start counting on Tuesday, and you would get Tuesday, Wednesday, Thursday, Friday, and Saturday. However, keep in mind that the sheriff does not often perform lockouts on weekends, so they probably wouldn't come back to Monday in that example. After the 5 days are over, the sheriff will return and escort you and your family out of the rental unit, and the landlord will change the locks. Remember, only a Los Angeles County sheriff can lock you out of an apartment. The police cannot, the landlord cannot, the landlord's employees cannot. Only the sheriff. The landlord or landlord's workers must not remove you from the unit without the sheriff's help. If they do, that's called an illegal lockout. If you are subject to an illegal lockout, you will want to contact an attorney for legal assistance. If you lose your case and are subject to an eviction, the sheriff will post what we discussed. It's called a notice to vacate. The notice to vacate is a white piece of paper with red lettering that says you have 5 days until the sheriff can lock you out. Very often, the sheriff will knock loudly on the door to make sure that you're aware they are posting that notice. The sheriff will tape a copy of the notice to your door, and it will give you the exact date you have to be out before the sheriff can come, escort you out, and lock the doors. If you wait until the last minute to move, the sheriff will not give you time to pack your things. Usually, you will receive 5 minutes to grab what you can, and you will be escorted off the premises. The locks will be changed, and you will be ordered not to return. It does not matter if you have children, or are disabled, or sick. The sheriff will evict you. If you get locked out without your things, you only have 15 days to contact the landlord to get them back. If you don't get them back within those 15 days, the plaintiff can keep, dispose of, or sell any property left in the unit. Earlier, I said I would discuss stipulations later in the presentation. I'm briefly going to describe a few terms that you will want to ask for in negotiating a stipulation, regardless of whether you plan to pay and stay or move out. One thing you want to ask for is permanent, unconditional sealing. That means that the record in the case is sealed and you will not have an eviction on your credit, even if you lose. However, sealing is often contingent upon things like moving out on time. So while you want to get permanent sealing, if they won't agree to that, you want to make sure that you will abide by the terms of the stipulation to make sure that that sealing goes through. You can also ask for dismissal of the case after you comply with the stipulation. That means that the entire case goes away and is an extra way of making sure that you will not have an eviction on your credit. You will also want to ask for a waiver of rent, costs, and attorney's fees. That means you won't have to pay any money. You may also want to ask for a neutral credit reference that states only the dates of your tenancy and the amount of rent. That way a landlord can't badmouth you to future apartment buildings in case you need to find a new place to live. If you are doing a pay and stay arrangement, make sure to ask for a realistic payment plan so that you can make all of the payments on time without missing one. You may also want to ask for an opportunity to cure. That means if you fail to make a payment on time, you'll be given a little extra time, maybe 3 days, maybe 5 days, in which to make that payment before you're in default and have an eviction on your credit. Stipulations are often the best way to resolve a case, and you may want to have an attorney negotiate one on your behalf because they can be quite complicated and they are ironclad. Once you enter into a stipulation, it is very unlikely that you can get out of it or change the terms, particularly if the other side won't agree to do so. To contact LAFLA for information or legal advice, you can apply online by going to www.lafla.org/LAFLA self-help or by calling 1-800-399-4529 Monday through Friday from 9 a.m. to 12 p.m. You can also attend a LAFLA clinic, and you can find those at lafla.org/self-help/calendar.